Good afternoon, everyone. My name is Caroline Andresier. I am the professional support lawyer here at Evershed Sutherland, supporting the real estate practice group. Welcome to this afternoon's webinar, which relates to construction considerations for landlords in relation to the whole COVID-19 coronavirus situation that we find ourselves in. So good afternoon to everyone, wherever you may be working. Not many of us left in offices, I don't suppose, in these extraordinary times. I hope we are all staying at home and keeping well, working at our kitchen tables, in our spare rooms, or for one real estate partner in his utility room, I saw this morning. So my name is Caroline Andresier. I am joined today by Nick Pinder and Lucy Chadwick, both from our construction teams. Nick, good afternoon. Can you hear me, Nick?
I can hear you, Caroline. Good afternoon. Good afternoon to everyone who's joined the call. Trust you can all hear me all right.
Loud and clear. Thank you, Nick. And Lucy, are you there, Lucy Chadwick? Oh, a moment for Lucy. Lucy, do you need to come off mute before you say good afternoon to everyone? Oh, we seem to have lost Lucy. Okay, well, while Lucy dials back in, I will just cover our housekeeping. Everybody is on mute, as we have lots of people on the call and the background noise is rather disturbing, so only the speakers will be off mute. That doesn't mean, though, that we don't want to hear from you. Please just use the chat function to drop us questions or comments as we go. You can choose whether to address that question and comment to everyone, or you can use the drop-down arrow and pick my name, Caroline Andresier, and address the question just to me. And I will field questions between Nick and hopefully Lucy when we get her back on, hopefully as we go along. And either we will deal with questions as we go, if it's relevant to what we're talking about at the time, or else we'll pick up any questions we haven't answered at the end of the session. If we run out of time, and we will stick to finishing well within the hour, as it's hard to keep a conference call going for that long. If we haven't got to your question, or you want to raise a question after the event, then the last slide will be Nick and Lucy's contact details, and I'm sure that either the two of them or your usual Evershed Sutherland lawyer would be very glad to hear from you to pick up on specifics. So the session is being recorded, so we will be able to forward you the link after the event. Lucy and Nick won't be following the slides. I shall be their not-so-glamorous assistant to do that. Let's just check that we have got Lucy again. Lucy, can you hear us? Are you on the line?
Yes, I'm here.
Oh, hello, Lucy. Do you want to just keep talking for a moment, just to say good afternoon to everybody so Kathy can identify you on the caller list?
Sure, good afternoon. It's great to be here. Hopefully you can all hear me, and hopefully I don't drop off again. Apologies, my phone cut me out a minute ago. I'm so sorry.
Yeah, the perils of all this remote working. You've done very well to hang together so far. Okay, so just to check that Lucy is identified, and we'll put everybody else on mute, and I'll put just through the agenda. Right, on to our next slide, just what we're going to talk to today. Lucy will run us through landlords' obligations and the consequences of delayed completion, the likely impact of the whole coronavirus situation on construction projects that we have online at the moment, and then through contractor entitlement to time and cost when there is blame to be apportioned, who has to bear the responsibility. Then Lucy will hand over to Nick, who will talk about the closure or not closure of construction sites, including his own. Nick, I understand you've got the builders in at the moment, haven't you? And they're still going?
Absolutely right. So there's a certain irony to what I'll be talking about this afternoon as a disputes lawyer, but we'll come to that.
Okay. We might get construction noise from Nick. Then Nick will talk about practical steps that we can take to ameliorate the situation we find are in, contractor claims, and then with a thought to other contracts, the supplemental documents that we might also be dealing with. So that's our running order for today. As I said, please feel free to drop comments or queries as we go, either to everyone or to pick my name, Caroline Andresier, and I will direct the questions to Nick and Lucy as we go. Right, so Lucy will kick off. Lucy, I have put you onto slide number 1, your landlord's obligation slide.
That's great. So we just thought it would be worth starting off by just having a think about what obligations the landlords generally have in respect of base build refurbishment works being undertaken under agreements for lease. and what are the particular things that we should be thinking about given the challenges presented by COVID-19. Most of you who have entered into agreements for lease, in terms of general obligations, will be under an obligation to carry out, whether it's your base build works or your refurb works, to carry out those works in accordance with the specification, which has usually been pre-agreed, statutory requirements, in a good and workmanlike manner to be expected of a competent developer, and the usual good stuff around making sure that you're not using prohibited materials. But the key obligations that you really want to be checking your agreements for lease for at the moment are things like the obligation to complete. So generally we'd expect there to be an obligation to procure that the works are completed by a specified date. That obligation may be absolute, in which case the anticipated, it's usually defined as a target date or completion date, that's likely to be extended if specified events occur. Those events are likely to be defined, and that will be, obviously we'll need to check the terms of your specific contract, but generally they include things like any extension of time properly granted to your building contractor under in accordance with the building contract, contractor insolvency, and any delay caused by tenants. Some definitions may have a much wider catch-all, including things like anything that's beyond your reasonable control. So, for example, if you've agreed an extension of time with your building contractor, then you would be entitled to an equivalent extension of time under your agreement for lease. But depending where you are in your programme, it's really important to have a look at that, look at the date and any delays that you're experiencing now or are likely to experience in light of COVID-19. Conversely, the obligation to complete the work might be one of reasonable endeavours, and in which case that completion date may not be extended. And all you'd have to do in that scenario is just to be able to demonstrate that you've taken all reasonable steps to complete the works by the required date. Another obligation is the right to make variations. Generally, the position will be that you will have, as landlord procuring base build works under the agreement for lease, certain rights to be able to make variations without tenant consent. Generally, they're called permitted variations. And then anything else would require, any other variations would require the consent of the tenant before they're made. Commonly permitted variations, which are permitted without tenant consent, would include changes required to comply with statutory requirements, or if materials become unobtainable or their continuous supply can't be guaranteed, and in which case alternatives of equal or better quality can generally be used. And sometimes there's an additional proviso that any substituted materials mustn't alter the internal or external appearance of the works. Again, the specific drafting is going to be contract specific, but to the extent that any of you, and many of you may already be experiencing challenges and problems with supply, it's that sort of thing that it's really important to check now so that you can comply with the notice requirements under the agreement for lease, be having conversations with the tenant to agree the best way forward. Slight aside, but equally important and something that may get lost in terms of obviously there's so much to think about at the moment. There'll generally be an obligation under the agreement for lease for you to provide a security package to your tenant. That's either in the form of collateral warranties from your contractor and your design team or third-party rights. It's usually a precondition to lease completion, so depending where you are on the programme, you may have quite some time to be able to procure those, but it's still something to be mindful of to make sure that you're still actioning that and your project team is working with you to make sure that you can comply with those obligations. And we'll touch on later, obviously, in the virtual world, electronic signatures and things are becoming much more important, and we'll touch on how you can best use that facility to ensure your compliance in a little while. Caroline, if we could just flip on to slide 2, please.
Yes, certainly. Oh. I say that. Here we go. That's okay. Right, we're now on consequences of delayed completion, Lucy.
Fantastic. So, landlord has the obligations under the agreement for lease. What are the likely consequences to delayed completion going to be? Again, and obviously this is going to be a familiar thing, it will be subject to the terms of your contract, but generally it's either going to, if you can't complete the works by the target completion date, and that an event hasn't occurred which entitles you to an extension of time, generally there will be a liability to pay damages. There may be a delay to rent commencement, Or in the event that the works aren't completed by a long stop date, there may well be a right for the tenant to terminate the agreement for lease. So fundamental message here, again, is to check the terms of your agreement for lease to ensure that required notices can be issued and conversations can be had with your tenants. Many clients are agreeing at the moment to extend the target completion date and long stop dates. Obviously, we're in a very uncertain world at the moment, but I think the key there is to make sure that every date, if there is an agreed, if both parties are keen to progress, we want to ensure that the works are completed and that that lease can be entered into, then the date, the target completion date and that long stop date should be pushed out. And there's a lot of work coming through in terms of trying to get those arrangements in place for clients as quickly as possible. Just touching briefly on under the agreement for lease, there's likely to be two regimes. You as landlord will be obliged and will be undertaking or about to undertake works in relation to base build, and then when those works are complete or near to completion, there's very likely to be an obligation for your tenants to then carry out fit-out works. The usual position is that tenant obligations in relation to the fit-out works will broadly mirror the landlord's obligations in relation to the base build. A common key difference is that while the obligation to carry out fit-out works can be completed by a certain date, or it might be as soon as reasonably practicable, there's very rarely a consequence other than breach for failing to meet that date. But that's something you might want to check. The reason that the regime is different is obviously generally the lease completion will have been triggered at practical completion of the base build, but it's definitely something to pick up in your individual contracts to check what that position is. Again, in terms of
Lucy,
the same... Sorry. Yeah.
Lucy, can I just a question that's come through that seems right on point there, really. Do you think, I mean, we're talking about delay events and moving everything on. Have you seen documents? Are there documents that have this as a reason to delay? Is pandemic a reason to delay? And do we think that if it isn't now, it will be in the future? I think, can I be cheeky? I think it's obviously a very pertinent question. It's totally valid. I think it would be great to be able to pick up on that just in a little while when we've run through. I'm going to touch briefly in a moment on the JCT provisions and where we are, and I think that will half answer the question, and I think it would be useful to pick it up a little way forward if that's okay. Okay, Lucy, got that? Yeah, fine.
Okay, no problem. Just carrying on the tenant's works point, again, points to bear in mind. The tenant is likely to have limited ability to vary the work, so just check to the extent that they're going to may well be experiencing the same problems as you as landlord in terms of material supply and unavailability. So to the extent they need your consent to change those materials, they should be coming to you and seeking. So again, check the notice requirements and keep those communication lines running. And similarly, the security package, if you have tenants that are currently undertaking fit-out works and haven't provided their security package in the form of warranties to you, you need to make sure that those documents are still being put in place and they are still coming through. And again, I think staying in touch at the moment is the best way to achieve that. So, Caroline, if we could just zip on to slide 3, please.
Likely impact.
Yeah.
There we go.
Obviously, while in some ways it might seem a world away, but in some ways we're in quite early stages, very conscious that COVID-19 is already having quite an impact on construction projects across the UK and obviously globally. The potential impact is wide and varied and includes, to the extent that it's not already, it's going to include delays both to the works and to supply of goods and materials, labour shortages and unavailability of key personnel, unavailability of subcontractors or suppliers, meaning that you might be able to progress your projects to a certain stage and then you're prevented by not being able to carry on or complete a certain package. General disruption to services, and key and quite hot topic, which Nick will discuss a bit in a bit more detail later, is site closures. And this can result from either a contractor taking a decision to close a site if they already have possession, or you as landlord deciding that you're going to make that call and close the site, or it may be we're not in that place now, but it may come to that there's actually a government instruction to close the site. So obviously the impacts are varied. What claims are you likely to face from your contractors as a result of that? Many of you may have already received, and if you haven't, you may well soon receive early warning notices from your contractors advising of predicted or actual delay or increase in cost, and then potential claims for additional time and cost. And some of you, hopefully not already, may also see contractors seeking to exercise termination rights and suspend works. So picking up on hopefully answering some of the questions earlier, and if not, we'll pick it up separately. Most of you will be procuring works on the basis of JCT. And I think now, and Caroline, if we could just move to the next slide, please.
Mm-hmm. There we go.
Just look in a bit more detail about what do the JCT forms entitle the contractor to in terms of additional time or cost, or do they give them a right to suspend or terminate works? Obviously, generally the JCT will have been amended rather than entering into a standard form. And again, we need to check the terms of your specific contract, but there's some definite general themes here. So taking sort of time cost separately, starting with time, under the JCT, a contractor must establish the occurrence of a relevant event to be entitled to an extension of time. Not only must they establish the relevant event, but they must comply with the notice requirements under the contract and establish that the notified relevant event has actually caused the delay that they're claiming, and that's key. Two relevant events under JCT forms appear most relevant. One is under 226.12, and that's relating to the exercise of statutory powers. The actual drafting is, so the relevant event is stated to be exercised after the base date, and that's the date that's stated in your contract, by the UK government or any local or public authority of any statutory power that is not occasioned by a default of the contractor or any contractor's persons, but which directly affects the execution of the works. So if the government exercises a power after that specific date by closing sites or borders or preventing essential deliveries to be delivered or quarantining an area where the site is located, then that wouldn't be an activity that's due to the contractor, and it would directly affect the works. Obviously, at the moment, there hasn't been any government order, so strictly that is unlikely to apply at the moment. Secondly is, and probably two of the most commonly used words at the moment in the construction industry, force majeure. There's no strict definition under English law, and again, it will depend on the facts of each case. But the JCT force majeure reference is likely to be restrictively interpreted given the other relevant matters listed. So the contractor would need to show that not only has performing its obligations been made more difficult or more challenging, but it's actually been prevented from doing them. And that's quite a strict test given the current scenario. So obviously, they haven't been told that they've got to close sites, so they can keep working provided they comply with health and safety. So whilst under a strict interpretation, force majeure may be, if it was tested, be deemed not to apply at the moment. We're seeing a lot of clients trying to get their projects through. The ultimate aim is for everyone to come through this and working with their tenants and agreeing with their tenants and their construction team to agree a way forward, rather than saying, actually, there is no entitlement to an extension of time at the moment. So they are the two most directly relevant at present. As the situation progresses, other relevant events may arise. They might include, so if you decide to change your work, that might be as a result of changing access or working arrangements to the site. If you issue an instruction to postpone the works that you're undertaking, if you as landlord and employer under those construction documents or your team are delayed from performing your obligations under the contract, so that might be, for instance, in providing design or approvals required under the contract. Obviously, access, if access is restricted or prevented totally, or if any statutory approval process is delayed, so there's contractor has to obtain consent, and actually the approval process is delayed because people aren't in the office and the approval process is slower. All those scenarios would constitute relevant events under the JCT, and they may be the subject of claims for extension of time going forward. I think what is important to remember is even if a relevant event has occurred, the contractor will only be entitled to an extension of time if it's used its best endeavours to prevent delayed completion of the works. Again, best endeavours isn't clearly defined under English law, but generally the understanding is that the contractor would have to demonstrate that it's taken all commercially reasonable actions, which would include incurring reasonable costs. That might be reprogramming and diverting reasonable resources in order to prevent the delays to completion. So when they submit those claims, and Nick will talk about the sort of evidence and documentation that you should be asking for and making sure is in place, it's really key to be able to look at that before assessing any claim. Moving on to entitlement to extra payments. In order to establish an entitlement to additional money, the contractor will need to identify that either there's been a change to the works, that might be a change to working restrictions, for example, or a relevant matter has occurred under clause 4.21 of the JCT. The relevant matters entitling a contractor to loss and expense are much more limited than the relevant events and are largely concerned with acts and omissions of the parties. So by way of example, the statutory powers and the force majeure that we discussed a moment ago, they're not relevant matters under the JCT. So whilst they might entitle the contractor to an extension of time, they wouldn't entitle the contractor to loss and expense. So in the event of any relevant matter occurring, the contractor, similar to the relevant event, needs to comply with the notice requirements under the contract and establish that it's incurred a direct loss or expense as a result of the relevant matter that it's claiming, and which it hasn't been reimbursed under another provision of the contract. If you receive one of those claims, and Nick will touch a bit more on this, then your obligation as landlord and employer under those construction contracts will be to consider and respond within the required time limits to ascertain whether or not you consider that there is an entitlement to additional money or additional time in the case of a relevant event. Just touching briefly, suspension termination, obviously other concerns at the moment. The contractor doesn't currently have a right to suspend works. Do you as employer have a right to suspend works? There's two scenarios here. If your contractor hasn't taken possession of the site, then you have the right to grant a suspension of the site, provided that it's not longer than the period stated in the contract particulars of your JCT. That's generally not more than 6 weeks under clause 2.4. If any such suspension is ordered, then that would constitute a relevant matter entitling them to additional money, and also it would be a relevant event entitling the contractor to additional time. So if the contractor hasn't taken possession and you wish to suspend work, then you're entitled to do that under the contract. It just would entitle the contractor to time and cost. If they have taken possession of the site and they're already working, you can instruct instructions to postpone works if you wish to do so, but again, that would entitle the contractor to time and cost under the contract. Moving then on to rights of termination, if the works are suspended by reason of any of the following reasons, so whether that's force majeure, exercise of statutory powers, delay in statutory approvals, then in that situation, if the period of suspension is longer than that period stated in the contract particulars, and if none is stated, then that would be 2 months, then the contractor would be entitled on notice to terminate its engagement under the contract. Obviously, that's not to say that in these extraordinary times, you can't agree a different arrangement with your contractor in order to enable the works to continue as soon as possible. So I think moving on now to Nick, who's going to talk a little bit more about the closure of construction sites.
Thank you, Lucy. Site closure. The government published some further guidance on Sunday, which I'm sure lots of you saw, about social distancing. And that guidance contained a new section which didn't appear in the version issued after Boris was on TV last Monday, just over a week ago. And that further guidance provided that in the workplace and on site, employers should ensure that employees are able to follow the Public Health England guidelines, including, where possible, maintaining a 2-metre distance. So that remains guidance from the government. And as Lucy alluded to and spoke to earlier, there is no obligation on a landlord to close a construction site, absent any special arrangements. And I'm assuming here that you have handed over the site to a contractor. And generally speaking, it's a matter for a contractor to look after its people and ensure a safe means of working, and a matter for the contractor to consider how it's going to comply with Public Health England guidelines. Now, there are obvious practical issues for contractors associated with that, and in some instances there will be real concerns for contractors about the health and safety of their employees. But nevertheless, at the moment, we're considering this from a landlord perspective. And there is a hard line. I mean, I should say that the majority of conversations I've had with employer clients over the last couple of weeks, they have not been wanting to take a hard line. But I equally do have one client who's just come off the back of a lengthy adjudication with its contractor, where we were successful in arguing that the works were about a year late and they've barely started. At the very early stage of the project, they're already a year late. And there's not a lot of love lost between my client and the contractor. And the hard line they are taking is that nothing is impossible. As things currently stand, the contractor has to find a solution. It's got an obligation to complete by the completion date, and with due diligence. So at the moment, we're taking the line that if they suspend, that is unlawful, and there is a risk to the contractor. There must be a risk that their suspension, being unlawful, is repudiatory and may entitle our client to terminate. I'd say that's one out of, as you imagine, a lot of clients who've been advising on this. The vast majority are taking a less aggressive stance and a more pragmatic stance. And one thing that I want to mention there is that for many of you, you will have to bear in mind, and you will be bearing in mind, adverse publicity. And I think there are certain organisations out there, certainly a few in the city, who have already made the decision over a week ago to close down their construction sites, come what may, because they simply don't believe it's safe that they can continue to operate. And from a PR perspective, they don't want to be seen to be having a live construction site at the current time. And I know for some of our clients, even though it may result in the contractor getting time in addition, cost in addition to time, for reasons of publicity and other reasons, and the sector that they're in, they feel they have no choice but to say to the contractor, you need to stop working. We don't want you to continue. I think moving on to the next slide, Caroline, if we could, I'd like to talk about some of the practical steps that landlords can take to try and protect their position and ensure their projects ultimately succeed. So again, I'm making an assumption here that the vast majority of clients, landlords, employers in construction contracts will want their projects to succeed. And I think those employers need to be very mindful of how delicate contractor solvency and their supply chain solvency can be. Lucy and I were talking about this the other day. We've heard reports that margins are as low as 2 to 3% in the construction world. And a lot of contractors have very little headroom for the sort of shutdown that they're already experiencing. And what I can say from personal experience on a few projects over the last couple of years is that termination of your main contract or of a material subcontractor partway through the works has a catastrophic impact on your project. And all the theories, I don't want to do a disservice to Lucy and all the work that gets done around step-in rights that you will have seen in collateral warranties and things. It is, of course, very sensible to have all of that in place, and it works in respect of some of your supply chain. But the practical realities of getting your contractor and supply chain back on site, or another contractor on site to finish someone else's work, practicalities are challenging to say the least. And the costs to complete that I've seen on the jobs I've been involved in have been eye-watering. So I think the unprecedented nature of COVID-19 calls for employers to think very carefully about the line they want to take with their contractors, with the best interest of the project in mind. So I'll come back to that and just go to talk through a few other points that I would have at the forefront of my mind and be thinking about with my project manager, the people that I've got retained, possibly sitting at home at the moment, unable to walk around the site, but what can they be doing? And this also goes to the sorts of negotiations you may be having with contractors about their accounts, about payments. So the first thing I would look at is, where are the key designs and documents? Who's got those? Because normally it's the contractor. And if the contractor does go pop, or someone in his supply chain, then getting access to key designs and documents can be a real challenge. And certainly insolvency practitioners will not hand them over without you paying hard cash. I know that from being on the other side. Those are very valuable documents. You should do what you can to try and ensure that you've got them in your possession if you can. Lucy had mentioned earlier on contractual notices. The administration of the contract has to continue. It is worth digging out your contracts and checking what the notice provisions require, because sometimes you find they require personal service, personal delivery. If everyone's at home and offices are shut, that can be very difficult. So it might be worth agreeing with your contractor that, for example, email will be acceptable, and you perhaps want to ensure that a few email addresses are included, and you can include wording that says, provided you don't get a bounce back, an out-of-office reply, then the notice is properly served. It's worth thinking about those things before you get to the point in a month's time where you need to serve a notice and you find out that it's actually logistically very difficult to do. So pay less notices. I think in your position you need to be very careful. There will be savvy contractors out there hard up looking for cash. They will be making applications for payment in respect of works done at the moment, and they will probably be trying to make those applications as high in value as possible. And you will need to look carefully at the requirements to serve payment notices and pay less notices where you want to pay less than the amount that they have applied for. That is obviously very important, because otherwise you can end up with an adjudication risk where they become entitled to payment under the Housing Grants Act because the employer under the building contract has failed to put in the proper notice on time. And those, I'm sure lots of you are well aware of that, but those provisions, and that's a statutory regime, is very strictly construed. There's no leeway afforded because of COVID-19. I think everybody should think about how the downtime can be used most effectively. There is a lot of projects where you experience issues where the design can't keep up with the works, and that leads to delays down the line. So it is worth thinking about whether you can have a sensible conversation with your contractor and get some of his staff who are working off-site or from home to continue with key designs which frankly need to catch up. It is worth thinking about whether your specification can change to mitigate supply chain issues. Have you specified Italian marble, where marble from Wales will do the trick? Don't know if such a thing exists, but certainly Italian marble is going to prove a problem for lots of those high-end London developments. Milestone payments, it goes back to the contractor and supply chain solvency. I say I'm rather ironically, as a construction litigator, partway through my own project at home, and I don't have a roof on the house. Mercifully, I've got a very good contractor, a very good working relationship with him, and I've offered up to him that we will change the milestones because he's completely resequencing the works to get done what he can with what materials he can get hold of. But it means that he's got way more materials on site now than he would have had expected to have now. He has outlaid money for those, and I'm happy to take a sensible approach to paying him for those, because otherwise he just can't afford to keep working. And that's on a micro scale, but I think that works up the chain for a lot of large contractors. You need to consider site security. A couple of my clients have asked that question, whether they've been very concerned about site security in the event that contractor and the site is closed and there's agreement to close the site. And some of those clients have chosen, notwithstanding it's the contractor's obligation, they have chosen to take on that responsibility themselves. It's convenient for them to do so. They are going to bear the cost of doing so. They want it done properly, and they're prepared to cut the contractors some slack, frankly, in terms of hard cash outlay whilst the site is shut down. So that may be an extreme approach, but it's just an example of what some people are doing in the industry. I think you do need to look at the insurance position to make sure that if the site is shut down, that it remains insured. I think that takes me to the next slide, please, Caroline, if I could.
Yeah, there we go. Mm-hmm.
So I think
that's how landlords respond to contractor claims. Yes,
contractor claims. Mm-hmm. That's right. All on the right place in my notes as well. Yes. How do you respond to contractor claims, early warning notice of delay, or additional costs, or notification of site closure, those sorts of issues? I think the main issue that is going to arise out of this is delay, and issues of delay don't typically manifest themselves right now. I mean, we may see the closure of sites, but unless your project is particularly advanced, delay issues typically manifest themselves down the line when the contractors run out of float in the programme. You're starting to levy LDs, and at that point in time, you will want to know what the position is in respect of this particular event. So I think the most important thing that any of you can do with your teams, professional teams working on their projects, is you've got to establish the status of the work now. You need records, photos of where are the works up to at around the time when COVID probably really starts to take a critical impact on the works. So you need an up-to-date program if you can get one from the contractor, or you need to try and at least get the records so you can properly appraise any program the contractor does submit to you. You should get an inventory of what materials are on site, because that's going to help with payment. I think in terms of the impact of the event on the works, the contractor does have to show that the event has caused certain delay. I think you need to understand what delay is already built into the project. So how late are the works? What works can still be carried out? Can the contractor catch up? For example, design I mentioned earlier. I think it is important that any good contractor should be talking to you about their mitigation plans, and that's what they've already done, what they are going to do, and what steps they're taking to ensure efficient remobilisation. What are they doing about long lead items, for example? one thing that you should look out for is any opportunities to do commercial deals. Just today, I've just had a contractor accept an offer of my clients on a final account, and I'm absolutely certain they've done so because of the pressure they're under because of COVID. So that's an example of the client being able to do a better deal than they would otherwise have been able to do, and the offer of cash. But that's final account. I think the same goes if your project is going to be stalled for a month, 2 months, 3 months, who knows, then now's a good time to look at trying to do a line in the sand. Have you got a load of delay stored up that you know are lurking there in the background? Because this might be an opportunity to wrap them all up, pay the contractor some money for them, give him an extension of time, and then when you start the works again in June, let's say, you've got a clean slate, you know where you're going from, you've got an agreed program. So I think it's well worth using the time to explore those sorts of opportunities. And I think the final point I want to make is just to make sure you get something when you are doing any deals, and that might be getting certain key documents, designs that you need. If you've got a contractor who needs cash now, then think carefully about what else you might be able to get out of him and what he might be willing to give in these circumstances that you would like to have if, for example, the contractor were to become insolvent. So I think next slide, please, Caroline, my final slide.
Yeah, there we go.
Just to mention, thinking about other contracts that you might want to bear in mind, one, probably the most important type of contract to bear in mind that might be sitting in a drawer is any bonds that you hold. You need to check when those bonds expire. They sometimes have a long stop date on them, and if the date for completion of your works has already moved out, then your bond may be soon to expire. Calling on a bond during coronavirus is likely to be particularly problematic. So it's worth looking now at what hoops you would have to jump through in order to call on a bond. Sometimes you need your own bank to confirm signatories on accounts and all sorts of things. That is all going to be more problematic in the world we're currently living in. So that I think is very important. Funding agreements, they will be tend to be very bespoke documents, but they often contain default provisions around abandonment. I think really those specific terms need to be considered in light of COVID and any decisions as to what happens on site. But for those of you with funding in place and works, you need to look carefully at those agreements. And I think finally, collateral warranties, although Caroline, you've helped a lot of clients recently on the subject of execution of documents. So if you don't mind, I'm going to ask you to talk a little bit about what we've been helping clients do with that.
Sure. I mean, coronavirus has been a crash course in virtual working and electronic documents and electronic signatures. And I think, there has been a general trend, a sort of slow glacial trend towards electronic documents and electronic signatures that has now received a kind of seismic shift as people try and work out where they've got to get hard copy documents to people with wet ink signatures and what happens when those people perhaps are beyond reach of a courier or are too poorly to sign. So collateral warranties are usually executed by way of deed, and a deed, of course, requires signatory and witness, or two directors, something like that. Two parties actually have to sign it. Now, we're fortunate that most deeds can be signed by electronic signature. There has been a lot of, law back and forth and opinion back and forth, but we had a report in September last year from the Law Commission, which they gathered in evidence and worked academically on the subject and came to the conclusion that there was nothing to prevent a deed under English law being executed by electronic signature, and that actually such a deed could then be witnessed by way of the witness applying a second electronic signature. So two thoughts to that. Collateral warranties do do not need to be wet ink. They can go by way of electronic signature, so they do fall within the class of documents that could be electronic documents electronically signed. And even though there are deeds, we now can take comfort from the fact that two directors could affix their electronic signatures to that document, or one director and a witness could effectively execute that deed electronically. A couple of caveats to that. If you are witnessing a document that is being electronically signed, then actually the witness does have to be in the room with the signatory as they append their electronic signature. There was discussion in the LawCom report about witnessing a signature being appended by way of Skype or video call or the ever-present Zoom that we're all using now, or FaceTime call or something like that. That doesn't work. You do have to be in the same room as the person signing. You do have to see them do it. We do have some examples at the moment in residential situations of people witnessing through windows. Even, I leave the document on your doorstep, I retreat the obligatory 6 feet, you pick it up, I see you sign it through the window, you put it back on your doorstep, and then I can pick it up and sign it to show that I have witnessed it. Now that's where you need hard copy signatures. Electronically it works the same. And it's important to realise too that an electronic signature can take many forms. I'm sure shares in the e-providers such as DocuSign and what have you are probably one of the businesses that are really flourishing even in these uncertain times. But actually, again, the LawCom report makes it clear that a signature is anything by which a party shows an intention to be bound by that document. So you could use a system of DocuSign for collateral warranties, and it may well be worth setting that up if you've got lots to sign, but actually anything that takes the form of an electronic signature would work. And that includes typing your name in, simple straight typing, or using the function on Nitro Pro or Adobe where you can highlight pen and write it in. All those things show me that you have the intention to be bound by that document and therefore class as an electronic signature. So I'm hoping that this abruptness might get us over that initial hump and resistance towards electronic signatures, but there is no reason why plenty of these documents can't be executed even these extraordinary times. Okay, so...
Perfect, Caroline, thank you.
I know, that's a bit of good news to end with, isn't it, actually? There is a solution to one immediate problem. If anybody else has any more questions, perhaps they'd like to submit that through the chat function. As I've said, the recording, the presentation has been recorded, and if you want a recording of that, we can supply. Lucy and Nick, a couple of questions to put to you now, if I may, just before we end, because we're coming up to 50 minutes. Lucy, you mentioned that there was lots of cooperation going on, lots of people extending dates, looking at contracts and being in communication with their contractors and trying to do what they can. How is that all being done? Are we entering into formal variations? Are we trading emails back and forth? Is it a handshake and a word is my bond kind of thing? How would we best approach those moving timetables?
I think there's probably a variety of things happening. What I've seen most recently is clients are trying to take the line of reserving their position understandably, but contractors are obviously anxious, they're really concerned about their jobs, about their income, personally and professionally, and the response that has been given by employers is, so they've received early warning notices from their contractor for both time and cost, and sometimes there's a knee-jerk reaction to go straight back, but actually having spoken to them, they've gone back to the contractor to say, look, we understand the position. These are extraordinary times. We want the project to continue. We understand that you might be impacted. That said, we have got a contract in place. So let's stick to the mechanics under the contract, i.e. following all the advice that Nick gave in terms of going back to the contractor to say, understand the position. Please provide us evidence of the delay, your program. Where are you now? Let's get all the documentation in place, and then we will work with you to consider it. So I think it's a lot about the delivery of the messaging in place to give them some comfort, obviously without actually formally varying or formally granting any extension of time. There has been some suggestion from clients that one in particular was considering whether or not to say, look, would it be worth us just giving them an extension of time as a sort of goodwill gesture? And actually, on further consideration, the answer to that was, I'm not sure that it is, because at the moment, we're not sure that force majeure would necessarily apply. So, as Nick said, I think before giving anything away, you just need to be careful of, is that really in your best interest? But that doesn't prevent you going back to the contractor to say, we are one team, we're with you, give us everything you've got. To the extent that coronavirus is delaying you, that it is genuinely causing you to incur additional time, and you are doing everything you possibly can to mitigate that, of course, we're going to work with you to get through this.
Okay, thank you. And Nick, with the benefit of 2020 hindsight, what can we do to future-proof ourselves from this kind of thing, if should it happen again? Please God, not in our lifetimes.
Wow. Well, I suppose there's some of that work starts with at the drafting stage, and I think it's unlikely that a contract's going to get through a legal review without somebody putting a pandemic in as a listed relevant event and considering what will happen in those events. But I think beyond that, really it's what ordinarily goes into a thorough project management on any project, because the likelihood is that the next big thing that comes along won't be a pandemic. It will be heaven forbid, but a terrorist event or something else that we haven't quite thought of, and the impact that it might have. And really at that stage, for me as the litigator, it's all about your proper records of what's going on your construction site, and not allowing your contractor to have a better record of what's going on than you do, which is all too often the case, and being able to, requiring your contractor to provide you with programs in a format that you can interrogate them. So don't let them just give you PDFs. You want to be getting them right from the start, to give you them in a Primavera type format so that you can interrogate them and see what the links are between the various steps. And then having somebody, your project manager or equivalent, going through that program on a regular basis and seeing whether what is built on site is actually there. The number of times programs are made to match payment applications all too often, rather than to actually mirror the state of the works. And the more control you can have over that as an employer, the better. And it's about setting off on the right foot. You need to start as you need to go on with your contractor, and keep them on their toes.
Keep them on their toes. Right, well, we're all very definitely on our toes, aren't we, in these extraordinary times? As I mentioned, I will leave you with Nick and Lucy's contact details there on screen. And I'm sure Nick or Lucy would be pleased to hear from you with any further questions, or your usual Evershed Sutherland construction lawyer. Thank you very much for joining us today. We hope you have found the session useful. And I think all it remains is to say keep safe and keep well as we stay at home during this time. So thank you to Nick, and thank you to Lucy, and thank you all of us for joining. Thank you very much.